Okay, picture this for a second. You're in a London pub, you make a deal, you scribble it on a napkin. Now, imagine doing the exact same thing in a New York diner. Believe it or not, one of those deals might be totally legally binding, and the other, completely worthless. So why is that? Well, it all comes down to a really fundamental difference in how the US and the UK think about a promise.
So, yeah, how is that even possible? How can a simple agreement between two people be a rock-solid contract on one side of the Atlantic and just, empty words on the other? That's the big question we're going to unravel right now.
All right, let's get right to the heart of it. It's really all about a huge philosophical split. The UK legal system is all about tradition, strict rules, and certainty. Think of it like a perfectly straight Roman road. It's predictable, you know exactly where you're going. The US, on the other hand, it's more like a winding river, focused on flexibility and ultimately what feels fair.
But before we get into all the ways they're different, you've got to understand that both of these legal systems actually start from the exact same place. They're kind of like two massive branches growing from the same ancient legal tree.
And that shared foundation, it's built on these three key pillars. First, you need a clear offer. Someone has to put a deal on the table. Second, you need unconditional acceptance. No ifs, ands, or buts. Just a clear yes. And finally, you need something called consideration. That's the price of the promise, what each person gives up to make the deal real.
Okay, so we've got the foundation down. Now let's get to the really interesting part. This is where we start to see that huge Atlantic divide in action, and how those same building blocks can be used to create two very different legal structures.
First up, let's talk about offer and acceptance. This is what lawyers sometimes call a meeting of the minds. It's that moment where everyone's on the exact same page, agreeing to the exact same thing. But how perfect does that agreement really need to be?
And right here is our first major split. The UK follows what's called the strict mirror image rule. Your acceptance has to be a perfect, identical reflection of the offer. If you say, I accept, but can you deliver on Tuesday? Boom, that's a counteroffer. It kills the original deal. The US, though, is a bit more relaxed about it. Minor changes, especially in business, don't necessarily torpedo the whole contract. It's more about the overall intent. Next up is consideration. Like we said, this is the value that each person brings to the table. It's what makes a contract a two-way street, not just a one-way gift. Both sides have to have some skin in the game for it to be a real deal.
Now, this is where it gets really fascinating. How do they each define that value? The UK is super strict. The value has to be given at the time of the promise. So if your boss says they'll give you a bonus for work you finished last year, tough luck. That's called past consideration, and it's not valid. The US, though, has this powerful idea called promissory estoppel. It basically acts as a safety net. It says if someone makes a promise and you reasonably rely on it, a court might enforce it just because it's the fair thing to do.
Okay, so let's say you've got your offer, your acceptance, and your consideration. You've checked all the boxes, so you're all set, right? Well, not so fast. This is where enforceability comes into play, which is really just the question of whether a judge will actually step in and force someone to keep their word.
And again, a big difference. The UK likes to draw a really clear, bright line. Social promises, like telling your friend you'll help them move house, are generally not seen as legally binding. Business deals, though, the law assumes they are. But in the US, it's all about context. The main question isn't just, is this social or business, but was it actually reasonable for this person to believe and rely on this promise?
I know this can all sound a little abstract, so let's bring it to life with some actual real-world examples. These famous cases are the battlegrounds where these different legal philosophies were actually shaped.
We don't have time to go deep on all of these, but let's just touch on a couple. Over in the UK, the Balfour v. Balfour case is the classic example that drew that line between social and commercial agreements. It's pretty much why your spouse can't sue you for promising to do the dishes and then forgetting. Then in the US, a case like Hoffman v. Red House Stores is a perfect example of that promissory estoppel idea in action. It's a huge reminder that even without a formal signed contract, a promise can still be binding if someone really relies on it.
And this really gets to the bottom line, doesn't it? This isn't just some dusty topic for law school. If you're doing business across borders, these differences are absolutely critical. A handshake deal that might be protected by fairness principles in the US could be totally worthless under the strict, formal rules of the UK.
So after that whirlwind tour across the Atlantic, let's just boil it all down to the key things you need to remember.
So here's the most important takeaway. Remember, both legal systems are built on those same three pillars: offer, acceptance, and consideration. But they use them to build very different things.
The UK builds a solid, predictable fortress of certainty. The US, on the other hand, builds a more flexible and adaptable structure based on fairness and reliance.
And that leaves us with this final, really important question. In our world today, everything's connected. It's not enough to just make a promise. You absolutely have to ask yourself, which country's rules are we playing by? Because as we've just seen, the answer to that question could literally change everything.